Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
We've got the prosecuting attorney, Ms. Goodrich here, Mr. Johnson for the defense, and the defendant is present as well. All right, and Mr. Johnson, have you had a chance to review the charging document with your client?
Yes, Your Honor.
And do you or he wish to have its allegations read?
No, Your Honor.
And how does he wish to plead to those charges?
I'm not guilty, Your Honor.
All right, we'll enter a plea of not guilty. Is a forensic center referral requested?
No, Your Honor.
What would be the estimated length of trial?
In 2 days.
Okay. Would this be appropriate for see, we might have it here. Are you available on the afternoon of Tuesday, December 23rd?
Just set something this morning. I just set an exam for 12 p.m.
Here?
No, in Ann Arbor.
Oh, okay. We don't want to do that then. All right. What about January 13th then? Would that work?
I have 2 jury trials scheduled in Shiawassee.
Well,
I don't think.
what about a Zoom appearance in the morning on the 23rd of December?
Say that'll work. And I was going to say the 13th. I think I'm in the 15s on both those dates, so I don't think it's likely that either of my trials will go.
Oh, okay.
But,
Okay. Do you want to do the 23rd in the morning on Zoom?
Yeah, 23rd, yes, Your Honor.
Okay. How about 9:50 a.m.?
Yes, sir.
Yeah. All right, so Mr. Rosencrantz, your next court date is going to be Tuesday, December 23rd, be at 9:50 a.m. You're welcome to appear in person or by video conference and consult with Mr. Johnson about how you want to proceed with that, okay?
Yes, sir.
All right, anything further from the defense?
Yes, Your Honor. I do plan to file a motion to quash.
Okay.
On this case. Will the court want to hear that on the 23rd? I mean, it's
Yeah, I
not
can
going to
do
be a
that.
lot.
In fact, why don't we do it at 9:30 instead of 9:50, and then that'll give us plenty of time before the 10 o'clock docket to hear that motion. And
Does the court know if the transcripts are ready?
I don't. Did you order them or?
I believe so.
Okay.
I'm not sure.
Yeah, I don't know. They're not. A copy is not in this file, so I don't know if it is ready. But
I don't think we received them yet. I don't know if they've been ordered.
I'll go downstairs and check.
okay. And if it's not ready in time for you to notice up that motion, feel free to get with my assignment clerk and get another date and stip to adjourn the docket call.
Yes,
It doesn't make sense to do a docket call if we're not able to hear the motion.
Yes, sir.
Okay. Anything else from the defense?
Well, I think there's going to be another motion in limine. I don't know how the court does it. On R&O cases, I like to file a motion in limine to see what law the court is going to give of the jury. I know under the jury instruction, it does allow for defense to ask for special instructions regarding.
Oh, yeah. So on R&O, you like to file a motion for basically for a special instruction?
Yes.
Okay.
Will the court want to hear that on the 23rd as well, or closer to trial if this doesn't resolve? Well, I guess
I'd be happy to hear it at the same time, but if there's a chance the information is going to be quashed, maybe we don't need to do that. So if you want to file them in serial fashion, that's okay with me. But if you want to hear them at the same time, that's fine too.
yes, sir. Thank you.
Okay. All right. Anything further from the people?
No, Your Honor, thank you.
Okay, we'll see them. Kaniszewski, is that how Ms. Garza wishes to proceed there?
That's my understanding, Your Honor.
Okay. The only thing, and Ms. Goodrich did alert me to the remand before the break, and I talked to my court administrator, and I would not do that. I know that maybe district court said that's the way they would like it. I would not do that.
Okay.
Because I'd be really concerned that then sometime down the future, when somebody's trying to see what record Ms. Garza has, the district court number would be the FY, and that is the same case as our FH file. And so I just don't know how in the world that's going to shake out in lien. It would show an arrest segment in a file that's now suppressed. So I won't do that. So you can dismiss it, and then you'd have to reissue it and have her plead to that way.
Correct.
So I don't know if that affects the timeline of whether you want, I mean, we can.
We did previously have it written up that way, so if Mr. Schlizzler's office could submit that one, and we can resubmit that to the court then that way.
Okay. Mr. Kaniszewski, do you understand what I'm getting at, and any objection to that way? I mean, it's maybe 6 one way, half a dozen for the other in terms of Ms. Garza's perspective. It's just a different process just to make sure we have clear record keeping.
Nope, I understand, and I'm in agreement with that.
Okay, so I'll go ahead and proceed to take the plea just to count 1, and then you can just submit the amended plea agreement, and then
We'll submit a nollie.
yeah, I suppose the nollie will be either at the sentencing, or if you want to move that forward, you can just submit the nollie as to the count 3, and then get that process rolling even before the sentencing.
We'll probably do it that way.
Okay. All right. So Ms. Garza, do you understand we're talking about, you know, how you're going to end up pleading to an impaired driving, but all you're going to do, that's going to happen in the district court.
Okay.
But what you're going to do here, if you want to, is plead guilty to the possession of cocaine with a sentence agreement for 7411, meaning the case would be dismissed if you successfully complete probation, the possession of cocaine.
Yes.
Do you understand that?
Yes, sir. Yes, sir.
Do you want to go forward with that?
Yes, sir.
Okay, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can have a seat. All right, Ms. Garza, guilty plea hearing is an important event that includes the waiver of constitutional rights that you have, so I want you to listen carefully. If you have a question, ask me. If you need time to talk to your lawyer, you just let us know. We can make that happen. You're offering to plead guilty to count 1, which is possession of cocaine. It's a felony punishable by 4 years and or $25,000 fine. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere?
No.
Were you on bond for any other case at the time of this incident?
No, sir.
Do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights you would have had at trial?
Yes, sir.
All right, I want to remind you of some of the more important of those rights. You'd have the right to be tried by a jury, and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. And you'd have the right to remain silent and not have your silence used against you, or to testify in your own defense. Do you understand those rights?
Yes, sir.
Do you have any questions for me or for your lawyer about any of those rights?
No, sir.
Do you wish to give them up and enter a plea under this agreement?
Yes, sir.
If I accept that plea, you give up any claim that it was caused by threats or by promises beyond the plea agreement. Do you understand that?
Yes, sir.
Also, when you enter a plea, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do that by filing an application for appeal. The types of issues that you could raise on an appeal would be very limited after a plea, much more limited than if you went to trial and were convicted. Do you understand that?
Yes, sir.
All right, the plea agreement provides in exchange for your plea of count 1, possession of cocaine, and a plea in the district court to a newly issued charge for impaired driving. Then there would be a sentence agreement for 7411 as to count 1, and the other charge, the contraband, would be dismissed. Do you understand the terms of that plea agreement?
Yes, sir.
Understand that sentencing agreement for 7411 is not binding on me. I don't have to follow it. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yeah.
Okay, because you wouldn't be getting what you bargained for. Does that make sense?
Yeah.
Okay, there is an important exception to that. If you engage in misconduct between now and then, let's say you absconded bond or violated bond or committed a new crime, then by your misconduct, you would lose the right to withdraw the plea, even if I didn't follow the sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you?
Nothing.
Is it your own free choice to enter that plea?
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count 1, possession of cocaine?
Guilty.
So Ms. Garza, back on September 6th of this year, were you in Sheboygan County?
Yes, sir.
Did you have some contact with law enforcement?
Yes, sir.
And were you in possession of the controlled substance cocaine?
Yes, sir.
Did you know that you were in possession of that substance?
Yes, sir.
And did you have any lawful authority to possess it? You're not a doctor or
Oh, no.
pharmacist, and
No,
it wasn't
sir.
prescribed to you.
No, sir.
In rare circumstances, believe it or not, it actually is prescribed. So
No.
you had no lawful authority to possess it?
No, sir.
Okay. Mr. Kanishewski, are you satisfied with that factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes.
And counsel, are you aware of any other promises, threats, or inducements?
None, Your
No,
Honor.
Your Honor.
Okay, and do you believe I've complied with the court rule, Ms. Goodrich?
Yes.
Mr. Kanishewski, you agree?
I do.
All right, Ms. Garza, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of the offense, so I hereby accept your plea. I guess, Ms. Goodrich, what are we doing here on the contempt sentencing, on the bond situation? Any plans or thoughts on that?
Your Honor, last I knew, they were unable to get her into inpatient yet. I was hoping that could take place, just based on her own statements of struggling with substance abuse, and I hate to see her sabotage her 7411 by releasing her.
Right, okay. Well, Mr. Kanishewski, my thought will be to continue the contempt sentencing. What I said last time is, I don't want to, for example, enter a judgment of contempt that says like 93 days in jail, and then you find her a bed somewhere and she's got to serve that sentence. To just set the contempt sentencing for the same time as the underlying sentence, keep her bond revoked because she was drinking a couple times on this bond. But then if you were to find inpatient treatment for her, I would certainly sign a stipulation for furlough for treatment.
So you're not open to reinstating her bond so she can get back to work, Your Honor? It's either inpatient or sit. Is that what I'm hearing?
Yeah, I think so, because she was drinking twice while on bond, and she was drunk driving, and I just, I'm not sure that she's able to just white knuckle it and stop without getting some treatment. And I don't want to have to bury somebody because she, can't get it together.
Okay, Your Honor.
All right, so what we'll do is we'll schedule this for sentencing on January 13th at 1:20 in the afternoon. That'll be the sentencing and the contempt sentencing. But again, Ms. Garza, if you or your attorneys are able to get inpatient treatment for you somewhere, we'll let you do that. All right. Anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
No, Your Honor, thank you.
Okay. All right. We'll see you then.